consider this inquiry and report to the Scottish Ministers on the application for a wind farm at Clashindarroch Forest, south of Huntly in Aberdeenshire, generally referred to as Clashindarroch 2. This is our second meeting concerning the procedural arrangements for the inquiry. I don't intend to repeat any of the general matters that were discussed previously. If you have an interest in that, you can refer to the note of the meeting, which is on the web page. You'll see from the agenda that the meeting is going to focus on updating where we are with the various topics that were discussed at the previous meeting. Some housekeeping rules. The meeting is being recorded but not broadcast live today. My colleague Callum will stay online. He'll be there in case of technical difficulties. In due course, the recording will be made available probably tomorrow, so you can view it back if you need to. In accepting the invitation for the meeting, you've agreed to be recorded. And obviously, although this is a virtual meeting, I'd still recommend that you turn your mobile phone off in case it disturbs proceedings, and obviously keep your microphones muted as far as possible to avoid unnecessary disturbances. And that just leads me to the general caveat now about COVID restrictions. If you're attending from your place of work, you'll be expected to comply with any relevant restrictions applying at the application. If for any reason I believe that you are not following appropriate safety procedures, I reserve the right to close the meeting until appropriate arrangements are put in place. And then I'll maybe just ask the other participants now all to introduce themselves, perhaps starting with the applicant.
Thank you, ma'am. I'm Marcus Trinnick, Solicitor of Queen's Counsel, representing the applicant. And I see that on the screen we have Kirsty Morris, Peter Nesbitt, and perhaps others whose names don't immediately appear. Thank you.
And the council?
Good afternoon, ma'am. My name is James Finley, Queen's Counsel. I believe I have Elizabeth Tully and Martin Ingham.
And I saw Susan Shaw from Living Law there.
Good afternoon, ma'am. Everybody, Susan Shaw, partner with Living Law. I'm joined today by Mr. Dominic Woodfield, who's specialist ecologist with Bioscan UK, and my client's principal, Dr. Paul O'Donoghue, who will just be joining in a few minutes.
Yeah, we'll look for him. Thank you. Just taking. And then we've got some of the interested parties that have opted into the proceedings. I see Mr. Newman from the last time, but maybe everybody could just pop their videos on briefly and just identify who they are, please. Thank you. Mr. Newman, maybe start with you. We've no microphone from you, Mr. Newman.
Muted it, sorry, I forgot. I'm from Bog Clark Lodge in the Clashindarroch Forest, and I'm an interested party for that reason.
I see, I'm not seeing everybody at the same time. Let's see. Sure, there was other people there briefly. Is it Mr. Hammock? Yep. You're muted as well, Mr. Hammock.
Goodness me. It's Richard Hammock of Friends of the Clash.
Thank you. I did see some other names, but they're not popping up here on the grid view that I'm seeing. I think I saw Mr. Mackenzie. Are you there, Mr. Mackenzie? Oh, there you are.
Good afternoon, Colin Mackenzie, interested party as a local resident.
That's great, thank you very much. And that takes us to item 2 in the agenda. I'm going to slot something in very briefly at that's not on the agenda. I'm going to break the rules straight off, and that's really just about the inquiry venue and the virtual process versus in person. Right now, you'll see there's a sort of a slight nervousness in the national press regarding the current COVID situation, we're not able to rule out fully that we won't be returning to a virtual inquiry arrangement in the new year. We won't know really probably till after Christmas whether there are any implications for the government's procedures. We mentioned briefly, I think at the last pre-examination meeting, the possibility of a hybrid event. That's something I'm not going to look at in any detail at the moment. We would really need to know if there was enough demand for it. It adds additional technology layers. I think if there is a COVID risk associated with our proceedings in the new year, I think it's more likely we would revert fully virtual. And if the risk was acceptable, then we would be fully in person in Aberdeenshire. In that respect, we are making good progress with the Gordon Hotel in Huntly, which was a venue suggested by the council. It appears to be large enough for our purposes, assuming we need to be spaced out across the room, and it's giving us good information on its internet capacity for the webcast. There are other details still to be resolved, and we'll confirm those as soon as the booking is made, and we'll let you know that that's where we're going. The other items under the current position were core documents, and I'll tuck into that the agreed matters as well. Both of those documents arrived as expected. Not seeing any problems with those in any detail. My only observation for the applicant is possibly the core document list. A very minor thing really is just a refinement to the index link list. There are a large number of environmental documents all given the same reference number, and I think whilst that's not a problem for us from the leisure of our offices and things, it might be useful for the inquiry and hearing process that these are given further reference in case we need to find them very quickly during the inquiry or hearing processes. That's maybe something for the final version of the documents. I'm also still expecting these to appear as memory sticks for the participants, so that we're not needing to use the whatever broadband capacity it exists in the hotel, that we're not having to use that to download large documents down to our own individual computers on the day. And the third item is really under where we are with the...
Just to come in on the core documents, I think
yes,
there are just two outstanding points. We're waiting, I think, to hear from Wildcat Haven. We raised some questions about their documents in an email of 2 December, and it'd be useful just to have a response on that. And the second point is, I think we're waiting for a number of hyperlinks from your case officer to enable us to complete that side of the CD list. And finally, we have set up the Collaborate extranet site with all the core documents as well. Thank you.
Thank you. I'll check with my colleague about the hyperlinks. I thought we'd provided everything that you needed, but if there's something that we've still to give you from our records, maybe get Mr. Kennedy to contact, I think it's Kirsty Smith that was the main contact for you on that side, and we'll just work out if there's something else we can help with. Thank you. Does anybody else have any queries on the core documents side of things? No, that's fine. Just the last thing was about the written submissions. This was really just about those that are not going to be covered by the other topics on the agenda. Just to confirm, the Cabrach issue has dropped away, and there's no longer any formal process associated with that. And just along those lines, obviously the representative, Mr. Kelly, had asked me to confirm that their objection would be taken into account. We received some recent guidance from Energy Consents Unit that any objections submitted direct to the council would not be included in our assessment, that we would concentrate on those representations submitted to the Energy Consents Unit. So I just need to check that what status these Cabrach letters have. But other than that, just to draw that particular change in emphasis to your attention. Mr. Trinick?
Yes, ma'am. On the question of the Cabrach representations, we haven't yet responded to those representations. I think we would like an opportunity to do so, and if we were to do so, we could do it by the 23rd of December.
Yeah, I wasn't, I suppose in a way I hadn't followed that up, because by them pulling out from the process, there was no longer a kind of outstanding matter for you to address. But I'm happy to accommodate that in the normal course of any kind of inquiry session, and to give you an opportunity to respond to their last letter, which was the summary I think Mr. Kelly produced before he withdrew from the inquiry process. So I think that'll be perfectly fine. So the 23rd of December.
Indeed.
And really that just takes us into the next item on the agenda, unless anybody has got any points on those summary of the current position. The next item, again, I allowed for it in the agenda because the cut-off point for submissions hadn't yet expired when I was preparing it. It was the 1st of December. I've not identified anything in the matters that have come through that would change any of the previous decisions I made at the pre-examination meeting in September. But I do still want to highlight to parties that the supplementary information did contribute a slightly more information on the noise matter, to make sure everybody has seen that, and we'll take that into account as we go forward. Does anybody have any issues to raise regarding any of the responses to supplementary information? Mr. Trinick.
Thank you, ma'am. Sorry, I'm doing too much talking. We haven't yet had a response from Nature Scott, and I think you'd expressed a wish that Nature Scott did respond to the supplementary information. That's my memory anyway. So I'm just noting that if you wanted to press Nature Scott to provide a response.
It's not a problem. It did come through. What I found this morning was some of them were still waiting to be uploaded onto the public website. I think they'd all gone slightly different routes. Some of them had come direct to you, some of them had come direct to us, and Nature Scots had come direct to us, and I think it was uploaded this morning because I noticed that some of them weren't there when I was preparing for the meeting. I can confirm to you it's not telling us anything other than it's just 2 or 3 lines. It's not introducing any new information or point of view, so I don't think it'll give you any difficulty.
There's also Scottish Forestry and Aberdeenshire Council. I don't know if we're expecting any responses from those 2 bodies.
I hadn't noticed anything Scottish Forestry. I'll have another look for that one. Aberdeenshire Council, maybe Mr. Ingram knows if there was a process still outstanding on that. Mr. Ingram, are you listening in, or maybe Miss Tully?
Perhaps I can assist. I'm not aware there is, but I'll check that during the course of the remainder of the hearing, and if there is, I'll come back.
Thank you, Mr. Finlay. Thank you. And that takes us to item 4, which is the topic of noise and where we are on the process. I'll just give you you'll maybe see from the amended timetable I sent out with the agenda what my thinking is on this. I've looked at the various exchanges and information that came through as written submissions, and it seemed to me that the focus is really on the terms of the noise conditions rather than the noise matter as a broad topic. And so my thoughts on further process are really to pull out a discussion on the noise conditions as a separate but part of the hearing session on conditions, and have a focus session on that would allow us to look at the difference of opinion, potentially introduce expert witnesses if there's a need be to look at some of the detail of these conditions, and also allow any of the third parties that are interested in noise matter to perhaps just come along to that part of the hearing. That's not to say that there is obviously a policy matter that the council's interested in, and from my point of view that would be easily slotted into the policy hearing, which we've already got scheduled. So that would be my first thoughts on how to respond to the exchanges so far on noise, but obviously I'm looking for views from yourselves as to what you think about that. Mr. Trinick.
Yes, indeed. Yes. That all makes good sense. As long as we don't have any technical noise issues between us and the council. Now, we'll know more if we get a response from the council to the SI, supplementary information, because that would tell us the answer to that, hopefully. The other thing is on the noise conditions. The council have been very good in dialogue with us on conditions generally, but we haven't had a response on noise conditions from the council. Now, I would hope that any dispute we have about noise conditions is a matter of drafting and not of technical evidence. But I'm just very wary until I know that, of committing to a view that there's no need for technical evidence. We need to know, because it's far too late once we get to the hearing session to discover that there is a technical issue that should have been debated. The other point that occurs to me is that it's not just the council. Professor Newman's views are equally entitled to an airing. Now, in his representations, we know that he is concerned about certain modelling aspects of noise, and he's concerned about amplitude modulation. Now, we've exchanged representations on those points, but it would be helpful to know from Professor Newman whether he wants to push those points further beyond his written submissions. That would be helpful to know. So it's just clarity on the position of the council I seek, and some further clarity from Professor Newman. Thank you.
Professor Newman, you've got a microphone issue again, Mr. Newman.
Briefly, I have been in consultation by email with the council. I've had communication which suggests to me that there's not a huge gap between my position and the position which the council appears to be either have taken or be moving towards. But I haven't seen a final version of what the council is going to say, just like the rest of us. So I would like to reserve the right to have a say in the policy session. But if it turns out, as I hope and expect, that the council is taking a position close enough to the position I would take, then I would then not take up the time.
Okay, that appears to kind of follow roughly where you are yourself, Mr. Trinick. Mr. Finlay, do you have anything on the noise matter that you can add to this?
Well, I think I hopefully move matters a little bit further forward. Our current position, or the position as I currently understand it, is that it is not likely to involve a policy issue. It is likely to be about terms of the conditions, so that your suggestion, the way of dealing with it. Having said that,
or Mr. Finlay, your comment going there.
Sorry about that. Hopefully you can hear me now.
Yep, I can hear you now.
My experience of noise conditions is that they can get quite technical, even though you're talking about a condition, because it is difficult to distinguish between purely drafting matters and other matters. So that I would hope that we'd be able to continue the work that has taken place on conditions to include noise conditions to seek to narrow the differences, so that if there is a need for any form of technical evidence, that will become apparent well before the inquiry.
Right, okay. It gives me a little bit of a quandary in terms of overall timing, because obviously we're looking to probably settle as much of the timetable as possible in the next, well, as a result of the note of this meeting. So there's a certain, I'm a little bit uncertain if there's still some technical discussions still to have. Might be something we need to take some responses from on you after the meeting and see if we can really firm that up. I had a particular question which might be worth raising just now, and the draft conditions that were produced in November do produce two sets of noise conditions, one set preferred by the applicant, one preferred by the council. there's a certain drafting problem, and I'm not saying in terms of the grammar, but in the way that they're laid out on the page, where two tables are attributed to the council's condition. There are two sets of guidance notes. One of them seems to be the council's preferred guidance note. The other one seems to be presented as an approved or agreed set of guidance notes. These are the guidance notes on these rather complicated noise conditions that are that come from the energy consents preferred template. So there is some issue about the way that the noise conditions have been presented so far in that document. So there's still some things to do on that, I think, to kind of just firm up what the two different opinions are on the terms of these noise conditions. But I'm really keen not to drag this on any further than necessary, because I'd really want to know whether we are having an actual hearing on noise, or whether or not we are looking at a conditions hearing with a noise session within that. I'm just wondering how quickly we could get to the point where we can resolve that. Do you think this is something we could resolve by the end of next week, for example? Whether we could get to the bottom of what the actual noise, the problem is between the two sets of noise conditions? A bit more focused position, perhaps, I don't know.
Well, perhaps if I can, I do understand the position is essentially the difference between we accept that the matter can be dealt with by condition if appropriately worded. So the issue is as to what condition should be applied, as I understand it. So it is essentially a conditions issue, but what I don't want to disguise that what may lie behind that may require some technical evidence.
Yeah.
Ma'am, if I may, that's why I raised the issue, because I am concerned. Either I bring a witness at some expense all the way to deal with noise, or I don't. If it's not a technical issue, I can deal with the conditions. Otherwise, I will need a witness. And if I need a witness, I acknowledge what Mr. Finlay says, and I appreciate what he says. But what started out as a noise condition session can all too rapidly become a debate about technical aspects of noise. And we need to know whether we've got that kind of debate very quickly, because my witness has to prepare his evidence if that's the case. Now, the conditions were submitted on the 19th of November. We have sought to obtain the council's view on those conditions, most recently on 2nd December, but we still haven't heard anything. So I think the ball is firmly in the court of the council to respond to the noise conditions and tell us what the problem is, very specifically. If it's simply a matter of wording, fine, we can deal with it in the condition session if we don't agree it. In the meantime, we can provide you with an abstracted, from the general set of conditions, an abstracted set of noise conditions, which gives some clarity as to who says what, and that's what you're looking for. Yeah. I do look to the council and say, sorry, we need to know fairly soon what your position very precisely is.
I'm told that we should be able to make our position clear, certainly by the end of next week, which is, I think, the date you indicated, if not beforehand.
Yeah. That would be helpful. I think, as I would like to be reassured that the council's broader team, have looked at the additional information on noise that was in the supplementary information, because the applicant's position changed slightly. I'll not go into the detail, we're not here to discuss the detail, but I certainly got the impression it changed slightly, and it's important the council's written submissions on noise had been prepared before they had seen that, which is why I was keen to, and why Mr. Trinick obviously is raising that as well, is to find out really how they're responding to that information. So it could be that we have some kind of addendum to the previous process that kind of deals with where we are with the noise, that the council perhaps are content with the noise levels, perhaps something like that, that allows us then to go into the conditions hearing, debating how these noise levels should be treated in the terms of a condition, so that it becomes a focused drafting error. But I'd like to know that by the end of next week. I think that would be helpful. It could be that we reserve the time in the timetable, when we come to look at the timetable at the end of this discussion, that we keep some time spare in case we need it. I'm wondering whether or not if there's just one other thing about the draft conditions, and I'm just going to raise it here just because it's a great chance to catch it. There's a reference in those draft conditions to the English use classes order when for the definition of a dwelling house. It's right at the end. It slipped in from some other document. Maybe just check you update that when you're dealing with it next. I wonder whether it's worthwhile just very briefly going to section 8 on conditions, which was about, I was just going to have an update on where we are with the hearing session on conditions. I don't see, setting aside the noise conditions, I don't see there's any need to update our current arrangements for that we would set aside time to discuss any conditions that were remaining unresolved at the start of the year when the hearing statements are required. Are you happy that, are the parties happy that that hearing session just is progressing as we originally planned? Yeah, everybody's nodding, that's fine. So that's item 8 is covered. The only change I can see there, obviously, I think Mr. Kelly was going to participate in that, so but all the other participants would remain as originally planned. And that takes us to item 5, which is the session on landscape and visual impact matters. The only thing I was going to add to that, I think we've had confirmation that a Lynn Rutter would like to participate in the inquiry session. It's a third-party representation that's opted into the process. But other than that, I didn't see any need to change our arrangements that we've put in place for the landscape and visual matters. Mr. Trinick?
Yeah, sorry, ma'am. In the minutes of the first pre-examination meeting, you said that the hearing session would deal with landscape and visual, including nighttime effects, i.e. lighting.
Yes.
Now, my understanding, not my understanding, is I know we have agreed a lighting condition with the council, and I believe Mr. Finley must tell us that they don't intend to lead a case on lighting. I don't know if third parties intend to lead a case on lighting. Obviously, Rebecca Rylett's there and she will cover the point. But do I need, as my question, to think about calling regulatory or scientific evidence on lighting? I've got that evidence ready to call, but I don't want to call the witnesses if they're not required. So I need to know from, well, I think I know the council's position, but Mr. Finney will confirm. I need to know from Lynn Rutter and anybody else who's going to give landscape and visual evidence whether they want to engage on nighttime effects, and if so, on what basis.
I can confirm the council's not raising evidence on lighting.
We don't have Ms. Rutter with us today, so it's not easy for us to rule that out just now, but it's something I can correspond through my colleague Christopher Kennedy with Ms. Rutter, and we'll try and see if we can resolve that for you. The statement of case timetable is obviously January. It's not very far away now, so we should know fairly soon what the statement of case would be from Ms. Rutter. And I take, obviously, it's useful to know that the council aren't raising any information on, aren't raising any points on the aviation lighting matter. Mr. Trinick again?
Yeah, so the problem is about timing that I should have picked this up before, but the statements of case in the true sense are to be on the same day as the inquiry reports, which means that if we only hear from Lynn Rutter on the 17th of January that she intends to raise lighting in any detail, that's the day that Rebecca Rylett's evidence is due to be submitted in detail. So it's too late to react at that stage. We need to know earlier if that's possible.
Yep. Okay, we'll see if we can get some more focus on that. Obviously, we have Ms. Rutter's original letter of objection, which is in part on landscape matters, but we can double check whether or not there's going to be, if it's going to form part of our submission. We'll see what we can find out for you and see if that helps in your preparation.
Very grateful, thank you.
Is there anything else to do with the landscape and visual impact assessment session that we need to update at all? You'll see I'd allowed for a slight run over time in the course of the week, so I've allowed a little bit of time, not knowing what contributions would be made from the third parties. Nope, there's nobody else. That's fine. That takes us on to item 6. Right. We've obviously had, at the time I prepared the agenda, we hadn't had the submission from Wildlife Haven through Ms Shaw. Obviously there's been email exchanges since that became available. There's a little bit more to discuss than perhaps we'd originally anticipated. I see from the email exchanges that there seems to be 3 areas that there are still matters to resolve in terms of process. One is the availability of confidential information or data supporting the Wildcat submissions. Whether the written submission from Wildcat Haven has delivered the summary of technical matters that was intended, i.e. to assist the applicant in understanding the scope of their concerns, and whether on the basis of the information that we have today, whether there is still a basis or a need for an inquiry session. It might be useful if I've covered those 3 headings sufficiently, whether we look at them in separation. Would you agree that that's the kind of 3 themes of your concerns? Mr. Trinnick, you had your hand up. You?
Yes, I do, and I'm ready to address them. It's probably fair that I indicate first why I think that the position is not very satisfactory.
Could we deal briefly with the confidential information first as a sort of separate issue? I know it links into the other matters, but just as to where we are with the confidential information.
Yes, the redacted information was, as you know, submitted on the 11th of November. It went to Chris Kennedy and it went to other parties. And the basis of the release of that redacted information was explained. Now, in terms of what they still want, the Wildcat Haven, I think we've been waiting for the non-disclosure agreement to be returned since the 12th of November. We haven't heard from them since. We don't know why it hasn't been returned. The remaining information which might be released can't be released until it is returned. So we're in their hands on that point. Over to Susan Shaw.
Ms Shaw?
Thank you very much. Obviously, there are some thorny issues which go around the confidential information as I understand it, and essentially they have hampered the preparation of further submissions by my client. You'll be aware that we have been trying to resolve this since prior to this application having even been lodged by the applicant. The redacted versions of the information were obviously submitted at the start of November, and we have been in discussions with them in terms of the non-disclosure agreement. However, the terms and the basis on which that discussion is proceeding mean that there are some complications as to who the information would be available to within Wildcat Haven's team. And that is obviously hampering potentially also the practical exchange of information between us and our witnesses. I don't know to what extent I'm actually able to disclose some of those discussions here, but I think it's fair to say that the discussions are ongoing, and I hope that we can actually pick up with that on the applicant next week. There have been exchanges subsequent to what Mr. Trinnick has indicated.
Well, if I may, we haven't heard from you since the 12th of November on this point. We're awaiting the NDA. But we can't release a lot more information. Firstly, because we can't, as a matter of law, into the public domain. We can release it on a redacted basis when we get the NDA signed. And we can't, for the other reason is because the information isn't owned by Vattenfall, it's owned by others. But this is well known. When we get the NDA, then we can release the further information to you. If there are further issues relating to the sharing of that information within your team, please do raise them because we are waiting to hear from you.
I think those issues have been raised and indicated, and we'll continue to exchange with you on that. I don't think we're going to be able to resolve the full detail of these matters today, but it is fair to say that we are proactively trying to have that resolved. So I'm not sure that we would at all agree with the assessment that's been put forward there as to the reasons for that delay. I mean, ultimately, all of this rests within the applicant's hands. It's their application, it's their submission, it's proceeding to their timetable. It's been known about for quite a considerable amount of time, and the terms of that NDA that were first put forward were extremely and unnecessarily onerous and have resulted in the need for further exchanges and submissions between parties in order to try to move them towards a format that would be in any way acceptable.
Ma'am, if I may just finish off this is going around the houses, I'm afraid. We have I haven't had an answer to the point. You've had the NDA since the 12th of November. We haven't heard from you. If you have continuing problems with it, you must raise them with us. But we've been waiting for you to return the document. It's as simple as that. And there won't be any more information until you do. And we are moving close to the submission of evidence. So I'm afraid those are the facts, ma'am.
I don't have the precise date in front of me right just now, but there were further exchanges, and I think it was actually, was it not the 24th of November that the last exchange was? We can double check that, but it was in the days prior to our lodging of further written submission, at which point we had sought further detailed information as to the basis of some of the information which wouldn't even be disclosed under an NDA.
Can I just check, Ms. Shaw, was is your discourse with Kirsty Smith, is that your contact?
That's correct, yes.
Okay, so it's easy enough to verify out with this meeting between Ms. Smith and Mr. Trinick as to what the current position is. I obviously I'm in a difficult position. I cannot interfere with the confidentiality matters. I can't interfere in the non-disclosure agreement. At some point we do need to move forward, and if we have to move forward with the information in its redacted state, then that's the way it'll have to be. I can't see another way around it. I have no powers to overrule. I'm not a legal court. I must accept the legal position of in terms of confidentiality or ownership of the data. So it's in everybody's interest. I mean, Mr. Trinick's not wrong. It doesn't really matter when the last email was sent. It's in everybody's interest that it is secured, because without securing some form of non-disclosure agreement, Mr. Trinick's clients are in a position they can't share the information. Really, it's everybody's interest that there's nothing else I can do. If it's running right close to the wire up until January before you're able to sort it out, well, it will affect your statement of case, and therefore, and I can't do anything about it. I don't think I'm going to delay the inquiry procedure to accommodate it. So it really is something you need to push on with this the inquiry procedure discussions to see if we can get to the bottom of it.
And I think we would agree with that, and I just want to make the point that we see it as essential that our witnesses have access to this information. So we'll continue the discussions out with this meeting, but that's a key point from our perspective.
Yeah. Okay. Well, then this takes us on to the second matter, and perhaps I will return to Mr. Trinick, and that really is about the written submissions from Wildcat Haven and their dual purpose, which was to look at the legal and regulatory matters, which we acknowledged was a written submission matter at our previous meeting. And I looked out my note of the meeting, and I just check where it had said that Ms. Shaw had suggested that her written submissions would also provide a summary of the technical matters that would form Wildcat Haven's case at the inquiry session. I saw from Ms. Smith's emails that there's an impression that the procedure was going to hinge on the summary of that case, but that wasn't the case from my recollection of the meeting. My understanding was that the summary was going to be of assistance to Mr. Trinick and his team by allowing him to focus and prepare witnesses and to prepare for the statement of case. So really, that I just really want to kind of park that we were committed to an inquiry session based on there being some summary of case to assist the applicant in preparation, in terms of preparation. So it's really, that's my understanding, and I'll return to Mr. Trinick now, obviously put his hand up. That's how where I want to take that from, is really this was about helping Mr. Trinick prepare on behalf of his client.
Indeed, ma'am, that was the purpose of the exercise, and it was my request at PEM1 that we should take these steps to enable us to respond to the evidence. Now, the purpose of the representations on technical issues, which were specified in Annex E to your note of the pre-inquiry meeting, pre-examination meeting, was precisely to inform the applicant of the basis of the case it had to meet in expert technical evidence from Paul Bradshaw. We know when the information was released, and we know where we are now. And I'm afraid at the moment that the statement of, well, the written submissions, I'm not going to call it a statement of the case, whatever they were, but we know what the purpose was, simply give us nothing we haven't already got to inform the case we have to meet to enable us to put evidence together. If Mr. Bradshaw was to be told, well, you're going to have to put evidence together anyway, it would be a 5-liner saying, I rely on what I said in the environmental statement. There's nothing else to say at the moment. If Susan Shaw says, well, we didn't have, and we don't have the information we need to put together a statement of case, I refer back to the letter of objection to the development of the 28th February 2020, multi-page letter, which went into huge detail, but it didn't give any technical basis. These were high-level assertions, not supported by any demonstrated concerns about, in particular, the baseline information about wildcat in this part of the Clashindarroch forest. I stress this part of the Clashindarroch forest, the development site in particular. We still don't have any detail of the case. We have nothing technical. We have assertions about precautionary principle. We have assertions about errors in the baseline. We have nothing to which we can technically respond. The fact is that Wildcat Haven were able to put together this objection in February 2020, and since then they maintain their position and want to be at the inquiry. I'm afraid, ma'am, it's as blunt and brutal as this. If they want there to be an inquiry session on technical issues rather than just exchange on legal issues, then they have to put forward some basis on which we can respond. It's as simple as that. Now, if they say we need further information, well, they may get it, they may not. Depends if they return the non-disclosure agreement. But they have got the redacted information. That's some basis for them to respond by way of a proper statement of case. Well, that is what we need as a matter of urgency. And I hope we'll get some direct response to this rather than further complaints about the applicant.
Ms. Shaw, how would you want to respond to that just now?
So, I mean, ultimately our position, I think, has been set out quite clearly that we need the information in order to be able to put the statement together. We've had release of redacted material, which has been in the applicant's possession for at least 2 years, and we've had that 3 weeks ago. That's obviously been a basis for us to start to make the technical submissions which are requested. Obviously, I don't need to tell you the terms of the Code of Practice, but it says that the procedure to be followed at inquiry is a matter for discretion of the reporter, and the objective is that it's to be conducted in a fair, transparent and efficient manner. I think ultimately we need to try to make progress with the NDA and push forward with the release of the confidential information. Our submission is that ultimately this was very clearly to be a further written submission. We've obviously raised very significant preliminary issues, which I think you will require a response from the applicant before you're in a position to determine. That response would be due on Monday. And at that point, that will obviously determine whether, for example, further environmental information is to be required. And then at that point, it would be open to you to make a further direction for us to make a further written submission, should you wish to do so. We'll ultimately be very happy to put forward the information which the applicant is seeking if we can get the information from them to enable us to do that.
I can respond, ma'am.
Yes, please.
We've gone around the houses without really getting an answer. The fact is that there has been redacted information. The fact is there was an objection in a multi-page objection in February 2020, which referred to baseline uncertainties. The fact is that Wildcat Haven are in a position to put forward now an inquiry statement where they make more specific contentions about baseline uncertainties, what they are precisely. That can be done. They haven't done it, and they need to do it very quickly. All we're getting is repeated bleatings about information in the possession of the applicant and the generalized assertions which are being made. We're far too soon to the inquiry to put up with just that. We need from Wildcat Haven to put up or shut up. Put up a technical case, tell us what we have to answer on the basis of the information you have, not on what might come forward if you sign the NDA. Let's see what you have to say, because I think at the moment we're in a position of determining the matter on the basis of written submissions you've got. There's nothing else to add from our point of view.
Right. Obviously, I really should take a little bit of time to consider the wheres and wherefores about this process. Ms. Shaw's right. We're trying to be fair. We're trying to give everybody an opportunity to participate and also the applicant a right of response. It's fairness on both sides. So it is important that these cases are explained and that people are able to participate and contribute appropriately. And you've got to remember as well, in the great scheme of things, it's an adage that passed to me by colleagues, the purpose is to help me tell the ministers something about this case, to report to them and make conclusions and recommendations on the implications of developing this wind farm. And really that's where we've got to work for. It's about being helpful to me, because the inquiry is about helping me write that report. And if we come back to that, the fairness, yes, the fairness is about exchanges and rights of response, but really it's about getting to the heart of the matter. So I have some sympathy with Mr. Trinnick, because I really want to know what the problem is from Wildcat Haven's point of view. It's important, it's clearly important to the group, and it's important that we understand if there is any shortcomings in the information that we have before us, and allow Mr. Trinnick and the applicant an opportunity to respond on that. The only thing I can do in terms of where we are right now is literally just go with the same deadline we gave for the noise matters and say we really need to know, have it all sorted by the end of next week. And that would be the cut-off point. If we don't receive anything in terms of a kind of focused structure to the areas of concern, I'm not going to pinpoint anything in particular. It's not for me to do that, but if I don't see that that's come through, then I'm inclined to combine all of Wildcat Haven's concerns in a written submissions exchange, and we might need to pull back from the inquiry, because there is nothing helpful to me to have an inquiry with no questions and no answers. So I think that's where I am just now. I think we need to have it sorted by next week, and I think if you are really having difficulty with the non-disclosure agreement, we may need to assume that that is the information you have to move forward from. And if that means that your case is based on the fact that there are missing elements of the information, then that's what it'll have to be, unless you can sort out the non-disclosure matters between now and next week. But I can't let it go on. I certainly can't let it go on beyond the sort of end of term, if you see what I mean, before the Christmas holidays. I think it would be unfair to everybody. We've allowed a little bit of space into the new year to finish off statements of case, but I would expect parties to be working on them now to make sure they've met these deadlines by the 17th of January. So end of next week, really, to get to the bottom of what your questions are, where your concerns are, in a form that is focused on the basis, with or without the confidential information. You can leave that as long as you possibly can, but to go any longer than that would impact on the inquiry timetable, and I think we would have to just revert to written submissions, because it's not going to be possible to put the thing together. I'll do a note of a meeting that kind of puts that in perhaps maybe slightly gentler terms. I think that everybody's getting a bit fractious with this at the moment, but I think it's important that we are fair to everybody, but that we're also fair to me, and that we can get a meaningful use of the inquiry time. Okay, so we'll give us another week or so to sort this out. Mr. Trinick, did you want to come back on that? I think you're muted, Mr. Trinick.
Sorry about that. We're due to submit our legal submissions and response to those of Wildcat Haven by the 20th, i.e. 3 weeks after the 29th of November. Well, we can, but the truth is that they wouldn't mean a lot because they're not anchored in any fact. These are simply legal submissions, a statement of the law. And to be fair to Living Law, it's a very thorough and very professionally put together document. We have respect for it. And a lot of it we agree with. But having a document that simply says, well, the law is more or less this, means nothing to you unless it's applied to the facts of the case. So my suggestion is that we don't submit those legal representations until we hear from Wildcat Haven by the end of next week, if they are going to say more about the technical side. If the answer is they're not, then I agree with you that written submissions are appropriate. We can then finalise our legal submissions and that will be the end of it. If they do produce more information, then we have something to anchor our legal submissions in, i.e. the facts of the case. So that's where we are in relation to that.
That seems a sensible adjustment. Oh, Ms. Shaw.
Sorry, I was just going to say, I think that the ultimate fact is that this is the most significant population of Scottish wildcats in the UK, and that this population is at significant danger. And ultimately, whilst I do hear what Mr. Chinnock said, the fact is that the applicant's EIA does not engage with the magnitude of that issue whatsoever. And I think we've made quite clearly very concrete legal submissions on which we are looking for the applicant's response to. And at that point, that may require a ruling from you on some of the preliminary matters that have been put forward. Ultimately, this issue has been squeezed from day one. The non-disclosure of information has been in order to attempt to reduce the ability for my client to meaningfully comment on these issues. And ultimately, Vattenfall may choose to play it that way, and we end up in a judicial review on the situation. So that's currently where we are. Either we address these issues properly as part of this inquiry, or they'll be addressed in accordance with the duty of candour towards the court. So I think it's in all parties' interests that this issue is addressed properly as soon as possible. Ultimately, we have no objection in putting forward a further written submission by next Friday, if that's something that would be helpful to you. I know that our ecologist has some further comments in response to the points that have been raised by the applicant already, and of course we'll be very happy to do that. Ultimately, this is about trying to assist you, as you have said, in order to advise ministers.
I'm not going to respond to that, ma'am, at this stage.
Yeah. Okay. Well, what I'm just going to do is summarise what I think we've kind of come to some.
Ma'am, if I may.
Sorry.
My name's it's Dr. Paul O'Donoghue from Wildcat Haven.
Oh, can you put your video on?
I've got really poor reception.
All right. Okay.
And
no, that's fine.
I'll drop out.
Okay.
I think it's really important I think it's really important that you understand the context of this and what's been attempted to happen here. You need the information. You need clear submissions from everybody, but we, as an organisation, need access to the data. Now, the redacted information we've got is overly redacted by any reasonable terms. Now, Susan hasn't spoke about this, but I will say, because it's important that we move on from this point. One of the conditions that Vattenfall are trying to put on the NDA is that the wildcat experts within Wildcat Haven do not see the data. That is clearly an attempt by Vattenfall to avoid any meaningful scrutiny. Now, Ma'am, you need to be fully aware of this. And that is a key sticking point in the NDA, because obviously we cannot sign an NDA whereby no one who with any wildcat background is allowed to see the data. And I'm just speaking plainly. Vattenfall are actually making this quite personal, which is wrong of them. They're actually specifically saying they do not want me to see the data. Now, you should know, ma'am, that at one point I was the only person in Scotland licensed to trap and DNA test Scottish wildcats. So my wildcat credentials are beyond question. I should be able to see that data. I should be able to scrutinise that data and put forward technical points. My colleague Dominic Woodfield also needs that data. It is ludicrous for the applicant to expect a proper technical report based on redacted information with no location information. Mr. Trinick himself, I'll use his own words, this part of the forest. Well, precisely, so we need to know which cats are in that part of the forest. Now, this is what Vattenfall are simply not releasing, and they're making the NDA so absurd as to be unsignable. Now, Ma'am, it's important that you know the background to this, and it's this, and from what I can see from this, it's a clear attempt by Mr. Trinick to close down the inquiry on wildcats because they know the importance of this issue. As Susan says, this is the most important forest for wildcats in the whole of Scotland. And the first development, Clashindarroch 1, should not have been carried out based on the wildcats that are there.
I'm going to stop you a little bit because obviously we can deal with some processes. I'm trying to avoid any discussion about the merits of the case. That's not the purpose of the pre-examination inquiry. I'm trying to keep the value judgments about wildcat out of it and stick with the procedural aspects as a priority.
Absolutely, ma'am. I totally agree. But you need to be aware that between the legal niceties and the clever statements, there is an attempt here to withhold information. We cannot provide and to hamper our case. We cannot. How can anybody provide a technical ecological report without the location data, using Mr. Trinick's words, on that part of the forest? And I can guarantee, I take the location data of wildcats that should not be disclosed to the public. It's very sensitive. I've worked on wildcats for 10 years. It's highly sensitive information, and we will treat it as such. But for Vattenfall to say only the solicitor and cherry pick who they want to see the data and not the actual wildcat experts is quite frankly ridiculous.
Okay, that takes us back to them from, well, just because I think that's taking us back to the things that we were not going to discuss, which is about the private arrangements between the parties. And we've asked, and well, we've agreed that the two parties will go and look at how best they might resolve that. Mr. Trinick, you wanted.
I'm going to ignore most of what's been said. It doesn't need a response at this stage. But what I will say is, it's quite wrong to say that we're forbidding experts access to the data. Mr. Woodfield, Dr. Woodfield, I think, apologies. Of course, he can see the data. He's the announced expert witness. But for reasons which I'm not going to disclose on this call, those who own the data are not happy that it should be shared more widely than that. That may be frowned on, but I'm afraid that's the case. We're not trying to close down this issue. We're actually seeking information that enables us to respond. Thank you.
Ma, might I just say something in response?
Okay. Yeah.
Very briefly, I'm not a wildcat expert. My role in this is to scrutinise EIA process and ecological impact assessment process. I'm not in a position to interrogate the data once it's released with the background Dr. O'Donoghue can. So this is I mean, Dr. O'Donoghue says it well. This is the major problem. The NDA is trying to restrict who can access the crucial information, and so complaints about the lack of detail or supposed detail in the first witness statement are simply a function of the applicant's approach to this problem. If the applicant discloses the relevant information, they will get a very fulsome technical response. They've had the best part of 2 years to do it. They've left it until 3 weeks before now. I don't think anything else needs to be said on that matter. I'm sure you've got the point. But the suggestion that releasing the information just to me is adequate is completely wrong.
Okay. I was about to summarise where we were, because I think that's going to be reasonably helpful to me if nobody else, is that by next week we want to see what progress can be made with the non-disclosure agreement that allows the confidential information that's so far redacted to be shared appropriately to allow Wildcat Haven to make a sensible and focused case that we could take forward to public inquiry, and that the deadline for that would be next Friday, which is the 17th. And we work to that, and at the same time we delay the submission of written submissions in response to the agreed written submission procedure, which was over the legal and regulatory matters relating to environmental impact and protected species, that we delay that until we've got that information. And it could be, I think it's going to be that we're going to have another, I'm going to have to make some kind of ruling out with this meeting or out with the note of the meeting as to how we move forward with this. I think that's the only way, but we need to see what progress we can make. And it's horrible to put pressure on everybody, and I'm sympathetic that there has been a period where the various parties, for whatever reason, have not been able to sort this out. But this is where we are. It's going to affect the inquiry timetable now, and I don't really want to let that happen. Ms. Shaw, you wanted to come back.
I just want to add, I think we're precisely where we expected to be. I think none of this is unfortunately coming as any surprise to us, but the international community are watching what is happening with this case, and it's in the interest of all parties that we try and get the actual substantive issues resolved as soon as possible. I take the point, and we will work on the further written submission that is sought for next Friday, but we would expect to see from the applicant a response to the very clear legal issues which have been raised as soon as possible. I mean, I don't really take the point that they all hinge on receiving this further detailed technical input from us. There are a number of preliminary issues in relating to the environmental information request that we think could be answered to the timetable that's already been set. And I would just ask that you give that further consideration, because it would help all parties to narrow the issues and for us to move forward with them in tandem.
Well, I wasn't intending on delaying the deadline for Mr. Trinick's response beyond the end of play before Christmas. I really would want all this done with December dates on it. So that certainly that's what I would expect, if at all possible, so that we can start the new year and know whether or not it's impacting on the inquiry preparations and the timetabling. Do you think we can, setting aside the ongoing discussions on the non-disclosure agreement, do you think you would be able to respond and finalise the written submissions response on the legal and regulatory matters before the end of December, or before the 23rd of December, Mr. Trinick?
Yes, ma'am, we can. What we say depends on what we get by the end of next week.
Well, I'll try my best to put this into the note of the meeting as a sort of structure for a way forward, but it does rely on everybody perhaps taking a big deep breath and seeing if they can find another way of finding a way to agree access to the information. I don't want to get involved in making judgments about who's right or wrong in this. It's just important that it happens, but I can't insist that it happens. I've made that point already. So I think we've got a way forward. It's not conclusive. If it affects the timetable, we'll deal with that perhaps in a week or 10 days time. But certainly before Christmas, we will need to work out if there's going to be an impact on the inquiry and hearing timetable for March. Okay. I think that's really all we can do on this matter. Yes, sorry, who's that speaking?
It's Paul O'Donoghue again.
All right.
I have one final point to make on this. There's also an issue of costs. We are a small organisation, and with meagre resources, trying to do the best that we can to save the wildcat. Now, at the moment, we're trying to prepare and pay for legal work, and it's a movable feast because we don't know what information we're going to get. So I just want to make that point that, you know, we've already had the Cabback Trust who have struggled to participate in this procedure because of costs, and this seems to be a tactic I've seen in other cases, and definitely in this one, where the applicant have deeper pockets and can simply outspend. So we need the information to put forward our case, and we need to also be mindful that we don't have a bottomless pocket. So I urge you to take that into account, and also Mr. Trinick should respond to Mr. Trinick is trying to dismiss what's in the written submissions. There are plenty of points for him to respond to, and I would insist on you asking him to make those points as agreed before on the 13th of December. I don't see why they should have any further latitude on this when it's their delay that is causing these issues.
Madam, if I may, I'm not sure who's speaking for Wildcat Haven in the spring examination meeting. We've had 3 contributors so far. I don't intend to add any more. We'll be ready by the 23rd of December, not by the 13th. Thank you.
Okay. The purpose is to try and round it all up as best we can, based on hopefully a movement further forward in terms of access to the information, and the benefit of moving back towards the end of December or before Christmas anyway. The final response means that can pick up possibly a move forward with access to data and a refinement to Wildcat Haven's case summary. All right, I'm going to move on to the next item now, because I don't think we can do anything more with that at the moment, I'm afraid. We've covered all the main topics, because I think we're just taking us to, well, we'll just have to turn on the page. Right, so just the hearing session was the next item on the agenda. The only update I really have for this is that Richard Hammock, who's with us today, has indicated intention to participate in the hearing session. Obviously, Mr. Kelly's clients have withdrawn from this session. The other parties will remain unchanged, and I've highlighted to you already that there might be an opportunity there just to look at the council's policy on noise that's been the cause of the objection. Really, just I didn't see a need to have a separate session just to look at that policy, that it would fit into that hearing session quite adequately. I don't see any need to change the timing set aside for that, which was going to be a half-day session. Is everybody content that the hearing session is going to just proceed as we originally intended? Is anybody contribution? No, that's fine. Thumbs up. Mr. Finlay's not having issues. That's fine. We've done item 8. We've looked at the hearing session on conditions. The next item was just the summary of case, and I'm really just highlighting again. You'll remember at the previous meeting, I suggested that the case summaries that we are, as an organisation, we're keen to see coming forward as a self-contained set of paragraphs to assist us in our report writing, that these I had suggested that they be in the statement of case. As that would be a kind of convenient time to prepare them. But I also saw from colleagues in another Section 36 case that they were being requested a standalone document to be delivered at an agreed date after the closure of the inquiry and hearing sessions, but being treated separately, but similarly, but separately from closing submissions, and where there would be no right of response or right to reply. I'm wondering if Mr. Trinick or Mr. Finlay has any views on that. Obviously, I think they may have been involved in some of these cases, and whether they've got any views on how we take forward the summary of case issue. Mr. Trinick?
Yes. I think this is an evolving topic, and I've seen several different views emerge. The view which I prefer, I'm not saying I'm right, but it's a view which has been taken in a case to be heard on the 10th of January, so you can track which one that is that closing submissions should be with but separate from closing submissions. Now, the reason I say that is that to get a summary of if the purpose of the summary of the case is to enable you to record the applicant's case in your report to ministers, then I don't think you're really helped by receiving a summary of the evidence before the inquiry, because that's simply a statement of what was the case at the stage of submission. What I respectfully suggest you need is a summary which records the position as the advocates see it after the evidence has been heard. In other words, a rounded position, taking account of cross-examination, because that gives the applicant's case at the end of the inquiry, and I think that's to be preferred. So my vote will be strongly for summaries to be perhaps in bullet point form, certainly very brief, but to be as an annex to, or certainly sent with but separate from, closing submissions. I think you'll be far better helped by that in terms of your report to ministers than simply us summarising what we submitted before the inquiry. Thanks.
Mr. Finlay, do you have a view on that? Obviously, you would be responding for the council's case.
I would agree with that. The logic of what Mr. Trinick has put forward is, to my mind, sensible. If it's to be included in the report, it should be the concluded position of the party. There shouldn't need to be a response, because if parties abide by the approach, what should be in the summary of positions should be the summary of the position as presented to the inquiry. The contentious part will be in the submissions, so that I would the timetable set out in the Kirkin wind farm inquiry doesn't provide for a response, and I don't see there should be a need for a response. You will have your own notes, and the summaries won't be written in stone anyway. And if you don't think they accurately portray what our final position is, whether it's the councils or the applicants, then no doubt you will reflect that in your own summary of our case. So I think Mr. Trinick's proposal is sensible. I can see it.
No, that's fine. I was really obviously had seen other examples of how other reports have taken it forward, obviously before we're going to have our inquiry sessions. So I'm happy to adjust that. I'm looking for the best summary of case. So if that's the one that comes at the end of the inquiry set and hearing sessions, then that's the one we'll go with. We're looking for it promptly, you know, so it will be on the type of timescales that you do for closing submissions, because we want to keep moving forward with the project once the inquiry sessions have finished. So that's fine. Ms. Shaw, you could be involved in this as well. I see you've turned your video off, but obviously you would potentially be providing a summary of case as well. Do you agree that that would be an acceptable approach for you?
Yes.
Yeah, that's fine. Thank you. I'll in the note of the meeting, I'll make that adjustment to the arrangements. The site visit update is item 10 on the agenda. Just to let you know, I've carried out an unaccompanied site visit, thankfully before that change in the weather. I'm not seeing a need for an accompanied site inspection for anything particular, but obviously I'm happy to take any views on that, and I may still have to review that as the statements of case come in and things, whether or not there's a need to revisit anything in particular. But if you do have a strong view on that, please let me know. But I'm happy just to progress with the unaccompanied work that I've done so far.
Well, we're happy with unaccompanied, man. We soon see no need for you to be accompanied, and I'm glad you've done it now. I think the snow will be arriving soon.
Yeah, I think I got a window of opportunity. Right, so that leads us really towards the end of the agenda, and that's about revising the timetable. I know there's we've left ourselves with some unresolved questions today. You'll see at the end of the agenda, I set forward a rough version of what we'd agreed previously, but I also looked at an alternative where we changed the positioning. My main goal here is, obviously I can see here that we've got enough material to quite conveniently sit within the course of a week, and I really didn't want to have a risk any overrun into the following week if we can possibly avoid it. But I did want to have a little bit of wriggle room in case either ecology or the LVIA matters needed a bit more time than we'd envisaged. I was also keen, and it's do we want to start fresh Monday morning early with the assumption that those that are coming from out with Aberdeenshire are perhaps having to come through on Sunday evening to prepare, including my colleagues in DPA, with the assumption that by Friday we will all be able to go home sharp and make sure we all get back home again by Friday afternoon, Friday evening. To me, that's a good goal in terms of planning out the week. So it's really whether or not there's any strong views for moving, swapping around the inquiry sessions, or whether you're happy that we start early or early-ish on the Monday morning and get the 2 days set aside for the LVIA as originally planned. I think we might need to start just slightly later than sort of 9:30. We might start at 10:30. Make sure we've got plenty of time to set up the function room and test the equipment. But if you're happy to kind of aim towards finishing earlier on the Friday rather than starting late on the Monday, I'm happy to work with you. But it's really just to get a feel from the participants. Mr. Trinick or Mr. Finlay, do you have a view as to how you timetable your week?
I'm happy to start on Monday and get down the road early on Friday.
Yeah, okay. That would then aim towards the first version, which is LVIA matters staying as session 1, taking up Monday and Tuesday. The inquiry session, if one still remains, for Wildcat matters starting on the Wednesday in the morning. We leave an overrun session for either session for the in the afternoon of the Wednesday, and then we look to try and do the policy in the morning of Thursday, the noise conditions on Thursday afternoon, and then we've got space first thing Friday morning to do all the other conditions if they are still in dispute by that stage. But we could drop off Friday morning if in the coming weeks we can get the areas of dispute on the conditions a bit more focused. I mean, we could possibly do the noise discussions and the other conditions in the afternoon of Thursday. That's my goal, but obviously I don't know what areas of dispute we'll be left with. However, if we do need to slot in more discussion on noise in terms of it being a technical matter, then that would sit on the Thursday afternoon. I think an afternoon slot over noise as a technical matter and as a conditions matter would work perfectly well in the afternoon. But I'll take, obviously, it's an unknown quantity at the moment. So I think if we stick with that, the first inquiry programme, I think we've got enough space to accommodate the changes that could occur as a result of the next set of submissions that we've been talking about today. So I'll stick roughly with the agenda in the main timetable. I'll delete the alternative option, and I'll add into the timetable a reference to the statements of case, which we would be looking at aligning with closing submissions. And I say the timetable then would be a kind of normally a 9:30 start, finishing between 4 and 5, but starting slightly later on the Monday to allow for technical testing and setups in the hotel function room. We're just not sure yet how early we would get into the hotel function room to make our preparations. Is everybody happy with that as a broad timetable and the gaps that it gives us to deal with the uncertainties that have come from today's discussions?
Yes, ma'am.
Yep, everybody's okay with that. That's fine.
Can I just say that?
Oh yeah.
On past performance, I think Mr. Pinnock is reasonably familiar with my witness and I with his, that we might finish the first inquiry session earlier, that might not take the full 2 days. I'm not suggesting necessarily be shorter, but there's a good chance it may be, and that it may be just something you might want to think about as to whether, if we do finish early, whether we simply draw stumps early on the Tuesday, or whether you provisionally consider another topic for any remaining part of Tuesday afternoon that's unused. Mr. Trinick will have as much an idea as I will about how long it's likely to take, but that's my provisional view.
Well, I think there's a little bit of uncertainty just at the moment, because obviously we don't know if the aviation lighting is going to be one of the discussion topics as a result of the third party involvement. Aviation lighting would take us down another discussion route, perhaps, than just the other landscape and visual matters that is of concern to the council. I'd be happier leaving the space just now, but I wouldn't want to try and squeeze in, if we have an inquiry session on ecology, for example, I wouldn't want to squeeze that in after the landscape in case we don't give it enough time. but policy matters might fit in. One of the downsides for us is, as an organisation, is that we do try to advertise and set out when these things happen, and changing, you know, so we have to be fairly fixed with start times for various sessions, so that we've properly advised people in any notifications and things that we've got the right times. Well, Mr. Trinick, do you have any views on trying to sort of tighten up the timescales on the Monday and Tuesday?
I tell Mr. Trinick, I agree with him. It won't go 2 days, the inquiry session on landscape and visual, but equally, if we have an inquiry, and in other words, this is work in progress, if we have an inquiry session on ecology, then I'd probably rather start that on the following morning than try and, as you say, squeeze it in starting in the afternoon. I'm very amenable to the thought of fitting in something else, but the trouble is that my policy witness will be coming up from Edinburgh, and it could get to be rather short notice to suddenly appear on Tuesday afternoon. Can we just leave that open for the moment until we know what's happening in ecology?
Yeah, I think so. We have a little bit of time to sort of reset the timings once the statements of case are prepared, and by then we'll know more about noise and the wildcat matters as to how they are being finally treated. And I think that there's a certain point where the DPA have to advertise the inquiry process, and that's the point where we need to have put in place confirm the dates and the times of each of the events, and that's the part that I can't come back from once that advert's been put in the press. Anything else on the timetable? Obviously, I'll adjust it to take into account the other discussions we've had today, but I don't see anything else from that just now. Is there any other matters that I've missed out that you feel you want to raise with me today before we finish? Right. Well, thank you very much for that. I'm sorry we've not been able to reach all the answer all the questions that we wanted today, but I think I'm really still hopeful that we'll get there before the close of play before Christmas. I'll issue the note of the meeting as soon as I can, but it's probably likely to be early next week rather than by Friday this week. But hopefully we'll pick up these changes to the dates as we go along. And we'll try our best to see what we can do with the basis of that note of the meeting to try and avoid as much as possible any further debates over process. But I'm not ruling out another meeting if we have to have one. Perhaps we maybe need to be prepared to have one if we've not able to get to the bottom of some of these matters to do with the wildcat process. But if I can do everything in writing, I will endeavour to do that rather than take up time. But that's what I would hope to do. Okay, well, I'll bring the meeting to a close, and thank you very much for your time. And we'll see you in March if I don't see you before, or February, I should say, the last day of February. Okay, so thank you very much.
Thank you, ma'am.
Thank you, ma'am.